The Supreme Court chamber fell silent as Judge Ketanji Brown Jackson stood at the podium, her expression shifting from skepticism to genuine surprise. Across from her, Representative Jasmine Crockett held up a document that no one in the room expected. "Your Honor," Crockett said, her voice steady, despite the tension, "I'd like to submit this precedent that directly addresses your concern." For a moment, Judge Jackson said nothing. The cameras caught her reaction as she reviewed the document, her eyebrows rising slightly. The entire room watched as the newest Supreme Court justice, known for her sharp legal mind and careful analysis, took a deep breath before looking up. "Representative Crockett," she finally said, "I think we need to examine this more carefully. This changes the discussion considerably." What followed over the next 30 minutes didn't just resolve a tense legal standoff. It revealed something profound about both women that would forever change how America viewed them till this moment. Judge Jackson and Representative Crockett had never faced each other directly, but their paths were different. Both had shattered barriers in their careers. Judge Jackson's rise to the Supreme Court was historic. She became the first black woman confirmed to the nation's highest court in 2022. With an impressive background that included Harvard Law School, experience as a federal judge, work as a public defender, and service on the U.S. Sentencing Commission. Known for her methodical questioning and deep constitutional expertise, she quickly earned bipartisan respect. Judge Jackson approaches every case with incredible thoroughness. Noted legal analyst Michael Roberts, if you want to see how a clash between powerful legal minds can transform into unexpected respect. Hit the like button and subscribe for more stories about today's most influential figures. She leaves no stone unturned, making her questioning particularly challenging for anyone appearing before the court. While the public knew Judge Ketanji Brown Jackson for her historic confirmation hearings, legal professionals admired her for something deeper: her remarkable ability to identify inconsistencies in arguments and her refusal to accept vague or evasive answers. Meanwhile, Representative Jasmine Crockett had forged her own groundbreaking path, civil rights attorney from Dallas, Texas. She had handled numerous high-profile cases before entering politics. Elected to Congress in 2022, the same year Jackson joined the Supreme Court, Crockett quickly gained a reputation for her direct questioning style and sharp legal acumen. Representative Crockett doesn't just ask questions for show, noted congressional reporter Sarah Jenkins. She asks them with a prosecutor's precision, setting her apart from many of her colleagues. Behind the scenes, Crockett had been preparing meticulously for this Supreme Court appearance for weeks. The case involved voting rights protections, an issue deeply personal to her as both a black woman and a former civil rights attorney. Her office overflowed with legal books, historical voting records, and stacks of prior court decisions. The stage was set for a pivotal moment at a special congressional hearing where Supreme Court justices were answering questions about judicial independence. No one anticipated conflict. These hearings were usually formal, respectful, and ceremonial. But when Representative Crockett was recognized to speak, the atmosphere shifted. She skipped the usual pleasantries and went straight to the point, challenging a recent court decision that had narrowed voting rights protections. "With all due respect, Your Honor," she said, looking directly at Judge Jackson, "I'm deeply concerned about the court's recent interpretation of Section R protections." Judge Jackson, not accustomed to such direct questioning in this setting, straightened in her chair. The other justices exchanged glances. This wasn't going to be a routine exchange after all. The hearing room, packed with journalists, legal scholars, and members of Congress, carried an air of formality and gravity. Wood-paneled walls, a vaulted ceiling, and sunlight streaming through tall windows set the scene. The Supreme Court justices sat in a row at a long table, with Judge Jackson positioned third from the left. Representative Crockett stood at the UHD congressional microphone, her red blazer striking against the dark wood backdrop. C-SPAN cameras captured every moment as she launched into her questioning. "Judge Jackson," Crockett began, "your dissent in the Harrison voting rights case argued that the majority misinterpreted Congress's intent. Yet the majority opinion cited your own ruling in Williams v. Georgia State Board from your time on the D.C. Circuit. How do you reconcile these positions?" The question was sharp, detailed, And potentially uncomfortable, it pointed to a possible inconsistency in Jackson's judicial record, something she was known to rigorously defend. Leaning slightly toward her microphone, Judge Jackson responded, "Representative, I believe you're mischaracterizing my ruling in Williams. That case involved administrative procedures, not substantive voting rights protections." But Crockett didn't flinch. "With respect, Your Honor, page 27 of your Williams opinion states that procedural requirements can have substantive impacts when they disproportionately affect specific communities. The majority cited this exact language to justify upholding voter ID requirements." The room tensed. This level of pointed legal scrutiny was rare in such hearings, and several justices shifted in their seats. "Context matters," Representative Judge Jackson replied, her tone firm. "That statement was specific to the circumstances of that case, which involved an entirely different statutory framework." Crockett nodded, then reached for a folder her aide had prepared. "I anticipated that response, Your Honor. Would you mind addressing these 3 other instances where your circuit court rulings appear to contradict your current position?" She handed the documents to the clerk, who distributed them to the justices. Judge Jackson took the packet, studying it carefully. The cameras caught her slight frown as she reviewed the contents. "These citations are selectively quoted," Jackson responded after a moment. "For example, in the Martinez case, the very next paragraph clarifies my position in a way that aligns entirely with my current views." The exchange grew increasingly technical and tense, with legal terminology flying back and forth as both women showcased their deep understanding of case law. Other members of Congress watched intently, some with discomfort, others clearly impressed. Midway through their exchange, Crockett shifted gears. "Judge Jackson, I'd like to move to a different aspect of voting rights jurisprudence, the historical understanding of the 15th Amendment's enforcement powers." Jackson nodded, perhaps relieved by the change in topic. "I'm familiar with the history, Representative. Then you'll recall Justice Thurgood Marshall's dissent in Mobile v. Bolden, where he argued that the court had betrayed the 15th Amendment's promise." "Of course," Jackson replied. "Powerful dissent, though not controlling law." Crockett paused, then asked, "Do you believe the current court's interpretation aligns more closely with the majority in Mobile, or with Marshall's understanding?" It was a carefully framed question, one that forced Jackson either to critique her colleagues or contradict her own past admiration for Marshall's jurisprudence. Jackson took a breath. "Representative Crockett, while I hold great respect for Justice Marshall, I don't think framing the issue as an either-or proposition is helpful to the legal analysis. Constitutional interpretation requires nuance." "With respect, Your Honor," Crockett pressed, "nuance can sometimes be a shield to avoid confronting fundamental inconsistencies in the court's approach." A low murmur moved through the room. Jackson's expression tightened slightly. "I disagree with that characterization of the court's work," she said firmly. Crockett nodded and reached for her final document. "Judge Jackson, are you familiar with Schaefer v. Montgomery County Board of Elections?" "I am," Jackson replied cautiously. "A relatively obscure Fifth Circuit voting rights case from 1979. Would it surprise you to learn that the reasoning in that case directly contradicts the majority opinion you joined last term in the Davis voting rights decision?" Jackson's eyebrows lifted slightly. "I don't believe that's accurate, Representative." "If I may," Crockett said, handing over another document. "This analysis compares the reasoning in both cases, paragraph by paragraph, and identifies 7 direct contradictions." As Jackson reviewed the document, her expression subtly shifted. She spent longer than expected reading it, occasionally glancing up at Crockett with a reassessing look. The chairman checked his watch, ready to move to the next questioner. "Your time has expired, Representative Crockett," he announced. "Mr. Chairman," Judge Jackson said unexpectedly, "I'd like to respond to the representative's last point, if I may." The chairman nodded, clearly surprised. "This analysis is—" Judge Jackson paused, carefully choosing her words. "More thorough than I would have expected. I would need time to review it properly, but on first reading, you've identified points that merit serious consideration." It wasn't quite a concession, but coming from a Supreme Court justice, It was a remarkable acknowledgment. Crockett nodded respectfully, gathered her papers, and prepared to yield the floor, unaware that beneath the table, Jackson had just scribbled a quiet directive on her legal pad. Pull Schaefer case files immediately. 3 days later, Judge Ketanji Brown Jackson sat in her Supreme Court chambers surrounded by legal texts, case law, and notes. Her law clerk, Marquessa Sharp, Harvard graduate, stood nervously as she reviewed his research. "This is comprehensive," she said, looking up. "And Representative Crockett was right, wasn't she?" Marcus nodded. "Yes, Your Honor." The Schaefer reasoning is fundamentally at odds with the Davis majority opinion, not blatantly. But in the underlying legal logic, I flagged the contradictions on page 4. Jackson nodded slowly. "And this wasn't raised in any of the Davis briefs?" "No, Your Honor. Schaefer was never overturned, but it's rarely cited. It seems Representative Crockett did some remarkable research to uncover it." Jackson leaned back, tapping her pen against her legal pad. "She didn't just find it. Marcus, she grasped its implications for our jurisprudence. That's impressive." Across town, Representative Crockett was in her office when the phone rang. Her legislative director, Taylor, picked up, then looked over with wide eyes. "It's the Supreme Court," she whispered. Crockett raised an eyebrow, but stayed composed. "Put it through." A formal voice came on the line. "Representative Crockett, this is Justice Jackson's judicial assistant. The justice would like to know if you're available for a meeting tomorrow morning at 9 a.m. in her chambers." Though surprised, Crockett kept her tone steady. "Yes, I'll be there. Yes, I can make that work." "May I ask what this concerns?" Crockett inquired. "The justice would prefer to discuss that in person," came the polite but firm reply. Finally, she spoke. "Well, it seems Judge Jackson wants to continue our conversation." The next morning, Crockett arrived at the Supreme Court building at precisely 8:45 a.m. after clearing security. She was escorted to Judge Jackson's chambers, an elegant space lined with floor-to-ceiling bookshelves and tall windows overlooking the Capitol. When Crockett entered, Judge Jackson rose from behind her desk and extended her hand. "Representative Crockett, thank you for coming." "Thank you for the invitation, Your Honor," Crockett replied, shaking her hand firmly. Jackson gestured toward a small seating area with 2 armchairs, and once they were seated, she got straight to the point. "I've spent the past 3 days reviewing your analysis of the Schaefer case," Jackson began. "Also had my clerks conduct additional research on the points you raised." She paused, meeting Crockett's eyes. "Your legal analysis was correct. The reasoning in Schaefer is fundamentally inconsistent with our approach in Davis." Crockett nodded but remained silent, allowing Jackson to continue. "What I find most remarkable," Jackson went on, "is not just that you found this obscure precedent, but that you understood its implications so thoroughly. Few attorneys, even those who argue before this court, demonstrate that level of legal insight." "Thank you, Your Honor," Crockett replied. "Voting rights law has been my focus for many years." Jackson nodded. "Clearly, but there's something else I wanted to discuss with you." Judge Jackson reached for a folder on the side table. "I've drafted a supplemental statement to my opinion in Davis that acknowledges the Schaefer precedent and attempts to reconcile the apparent contradictions," she said, handing the document to Crockett. "I'd value your perspective on whether this adequately addresses the concerns you raised." Crockett's surprise was evident, though she quickly composed herself. A Supreme Court justice asking a member of Congress to review her legal reasoning was not only rare, it was perhaps unprecedented. "I'm honored that you'd ask for my input, Your Honor," Crockett replied cautiously. Jackson nodded. "To be clear, Representative, I'm not asking you to write this or co-sign it. The final decision remains mine alone. But I believe in acknowledging strong legal arguments when I encounter them, regardless of the source." Crockett spent several minutes reading the document, occasionally jotting notes in the margins, while Jackson watched her closely. "Your analysis is thorough," Crockett said finally, "though I would suggest that the distinction you're drawing on page 3 between administrative burden and substantive impact might still leave room for the same contradiction to reappear in future cases." Jackson considered the comment, then nodded slowly. "That's a fair point. Would you elaborate?" What followed was an hour-long, in-depth legal discussion that would have challenged even the most seasoned constitutional scholars. Gone was the tension of the hearing. There was no posturing, no politics, just two brilliant minds engaging in serious analysis of constitutional law. As their meeting drew to a close, Jackson walked Crockett to the door of her chambers. "Representative, may I speak candidly?" she asked. "Of course, Your Honor," Crockett replied. "Our exchange at the hearing was uncomfortable for me," Jackson admitted. "I'm not accustomed to having my reasoning challenged so directly in that forum." Crockett nodded. "I understand, and I apologize if it came across as disrespectful." "It wasn't the tone," Jackson said. "It was the fear that I had missed something important. That's what judges worry about most." She paused, then added, "What you did identifying that overlooked precedent and grasping its implications, that's the kind of rigorous legal analysis this court needs more of." "Thank you, Your Honor." Jackson shook her head gently. "No, thank you, Representative Crockett. The law is better when we're willing to reconsider our views in light of stronger arguments." As Crockett exited the Supreme Court building, a reporter intercepted her, microphone in hand. "Representative, can you tell us why you were meeting with Justice Jackson?" Crockett offered a polite smile. "We were discussing constitutional interpretation. That's all I can say at this time." What she didn't say was that something extraordinary had just occurred, a rare moment of mutual intellectual respect that transcended partisan lines. 1 week later, the Supreme Court issued a rare supplemental statement to the Davis voting rights decision. It's authored by Justice Jackson, which acknowledged the long-overlooked Schaefer precedent and introduced a more refined framework for evaluating voting rights cases. Legal scholars immediately took note. Professor Ela Lawner Hamilton of Yale Law School appeared on CNN the following morning, saying, "What we're witnessing is remarkable. Justice Jackson has, in essence, said I missed something important. I'm correcting the record." That level of intellectual honesty is rare in any profession, especially in the judiciary, where consistency is often held as the highest virtue. On Fox News, conservative legal analyst James Porter offered a surprising take. "While I often disagree with Justice Jackson's conclusions, this supplemental statement shows remarkable integrity. She's prioritizing getting the law right." Over appearing infallible, social media lit up in response. The hashtag legal integrity trended for hours as users shared clips from the original hearing. Alongside coverage of Jackson's supplemental opinion,
Allah.
Students praised both women, with one viral tweet reading, "This is what happens when brilliant legal minds prioritize truth over winning. Take notes." Meanwhile, in her congressional office, Representative Crockett fielded dozens of calls from colleagues, legal advocates, and constituents, many curious about how she unearthed the obscure Schaefer precedent. "It wasn't luck," she explained to her staff in a morning meeting. "When I was practicing civil rights law, one of my mentors always told me to look for the forgotten cases, the ones never overturned, but quietly abandoned in legal discourse." Her chief of staff shook his head in amazement.
Oh.
"Well, it paid off. The Washington Post just called you Congress's constitutional scholar in today's profile." Crockett smiled faintly, but stayed focused. "What matters is the impact on voting rights jurisprudence. Justice Jackson's supplemental statement creates a pathway for stronger protections in future cases." At the Supreme Court, Jackson found herself in an unfamiliar but welcome position, receiving praise from both liberal and conservative colleagues for her willingness to revisit and refine her legal reasoning. Justice Samuel Alito, often her ideological opposite, stopped by her chambers one afternoon. "That was well done, Ketanji," he said simply. "Not many would have the courage to do what you did." Jackson replied, "It wasn't courage, Sam. It was obligation. If our reasoning is flawed, we have a duty to correct it." 2 weeks later, Georgetown Law School hosted a symposium on voting rights jurisprudence. Both Justice Jackson and Representative Crockett were invited not to debate, but to participate in a moderated conversation on constitutional interpretation. The auditorium was filled beyond capacity. Students sat in the aisles, professors lined the back walls, and thousands more tuned in via live stream. Dean Robert Mitchell introduced them with enthusiasm. Today, we have the privilege of witnessing something rare in our polarized times. Conversation between two brilliant legal minds who have shown that intellectual honesty transcends political divisions. As Jackson and Crockett took their seats on stage, the audience rose in a standing ovation. The two women exchanged a look of mutual respect before turning to face the crowd. "Before we begin," Justice Jackson said once the applause had subsided, "I want to acknowledge something important. Representative Crockett did what every advocate should do. She challenged my reasoning with stronger legal analysis. That's how our system is supposed to work." Crockett nodded in appreciation. And Justice Jackson did what every jurist should do. She prioritized getting the law right over being right. That's the essence of judicial integrity. For the next hour, the two engaged in a rich, deeply analytical discussion of voting rights jurisprudence. So rigorous that law professors would later assign the transcript as required reading. There was no political grandstanding, no point-scoring, just a masterclass in constitutional interpretation. Near the end, a law student raised the question many had been thinking. Has this experience changed how either of you approaches legal disagreement? Jackson paused, then answered thoughtfully. It's reminded me that even after years on the bench, I can miss important precedents. It's humbling, but necessary, Crockett added. It's shown me that behind the formal opinions and dissents, there are jurists genuinely committed to getting the law right. That gives me hope for the system. The impact of their exchange reached far beyond that symposium. Law schools began using their dialogue as a case study in effective advocacy. Briefs submitted to the Supreme Court increasingly cited long-overlooked precedents. And perhaps most meaningfully, the public caught a rare glimpse of what becomes possible when intellectual honesty rises above political positioning. 6 months later, during oral arguments in another voting rights case, Justice Jackson posed a question that caught many by surprise. "Counsel, have you considered how the Schaefer precedent might apply here?" Representative Crockett's analysis of that case has proven quite illuminating for the court. It was a small moment, but a profound one, an acknowledgement that sound legal reasoning deserves recognition, no matter its origin. That evening, as Crockett watched news coverage of the oral arguments, her legislative director stepped into the room. "They're calling it the Crockett Doctrine now," she said, smiling. "The idea that forgotten precedents can unlock answers to modern constitutional questions?" Crockett shook her head, returning the smile. "It's not about me. It's about the principle that the law moves forward through honest engagement with all relevant precedents, not just the convenient ones." The story of Judge Jackson and Representative Crockett didn't end with a dramatic confrontation or a political win. It became something far more meaningful. It evolved into a